It's my pleasure today to give you this workshop on privacy by design and what it entails. And I hope you're going to learn a lot together. So my experience is that if we start talking about your questions and about use cases, is that I learn a lot from this. So typically this is a two-sided thing. Never think that because you're a student, your questions will not be to the point. Most of the time they are so much to the point that I start to hesitate. So don't stop asking questions if you like. Also for the use cases that we're going to discuss today, it will be my pleasure to make my best out of it, but really feel free to answer things. So what's the menu for today? My idea is that at the end of tomorrow, so to speak, we have the second session tomorrow, you know personal data research is the basic principles of the General Data Protection Regulation from the EU, the 8 elements of privacy by design research, relevant aspects of storage of data and making them available for others, and the basic principles of the data protection impact assessment, which is one of the elements of GDPR. In doing so, you will have some practical experience in assessing use cases and in conducting such GDPR. So let's see. Well, let's start for today. We will have an introduction in research and privacy by design and what all entails and what personal information in research data is. And we have a group discussion on use cases. And tomorrow then we will have this data protection impact assessment role play, so which you will take part of a stakeholder in the use case and then discuss relevant issues when it comes to collecting and sharing data. So first, what is personal data? Well, perhaps it was quite already, but I would like you to tell me what you think personal data in research could be. Examples of personal data.
Name.
Name, yes.
Date of birth. Personal code.
Personal codes, date of birth. All right, yes, yes.
Education level.
Sorry?
Education level maybe.
Education level is also one.
Demographic other.
Yeah. So typically things you're now mentioning are what we call metadata about people, right? So data itself, raw data itself, can it also be personal data?
Yeah, sure.
Yeah. Voice recording. Other examples?
Yeah.
Recording. Thank you. The timer was always good, right? So you might think of.
I mean, social media posts as well.
Yes, right. Social media posts. Yes. Yeah, right. Surveys. There are many examples of these. So let's see if we've had them all. I think most of them speak. So we're on a good track. But personal data is any data that can lead to the identification of a living individual. We say living individual because this is also related to the GDPR, because GDPR, as we will see later, relates to living people, not to people who passed away. But this is interesting implications. Right. That's the quick. So it's an interesting thing to make a kind of division between types of identifiers. So there are direct identifiers, which can immediately identify a person, typically social security numbers, bank account numbers, even IP addresses are very important here. Also, when we're on a laptop, always have the same IP address. This is an identifiable data. National insurance number already mentioned, and there are indirect identifiers, which were also mentioned by you already when it comes to age, education level, gender, job characteristics. And the interesting thing is that typically you would need these indirect identifiers in your research design as a kind of independent variables. They are part of your research question. I would like to know what the score is on this and this, depending on age, gender, etc. Whereas the direct identifiers typically are not so relevant for the research as such, but for the administration of the research. You want to know who participated and how you can contact them again, and what the bank accounts if you have to give them a kind of remuneration for their activities. So that's an important difference that we can make distinctions of. And one thing I should also point out here is that personal data is really personal data when it can identify a person. So with the direct identifiers, probably you're good to go right away. But most of the time it needs kind of combination of identifiers. For example, if I know the age or age category of a person and gender, this is not enough to identify someone. This kind of personal feature, but it is not enough to say, okay, it is this person. But when I would start adding a kind of disease and perhaps location where people live, then things start being different, right? Combining these could indeed lead to the identification of that person, right? And it's also like this when you have a voice recording of someone. Not everyone will be able to say who the person is, but some people would be able to do this, and then it becomes personal information as well. It's not that everyone should be able to detect this.
Question.
Yeah.
I was just thinking about the name. I mean, it seems like direct identifiers are unique in and of themselves,
Yeah.
whereas other indirect ones are not. Like multiple people can have the same age.
Yeah.
But it's that combination. I was thinking about name.
Yeah.
I mean, some people might have a very common name.
Yes, right.
And is that direct? But then other people have very unique names.
Yeah, it's true. So there are always kind of exceptions where people have a very common name that perhaps the name is not directly leads to their identification, but it can be very a little extra. That's true. Yes. Yeah. Still, we would call names direct identifiers because they're very close to identification. Small thing to lead to direct identification. So, general data protection regulation from the EU came into effect in 2018, and the idea was that it would avoid, particularly companies, sharing personal data on all kinds of other customers and earn money with this. And this is why this came about. A direct consequence of GDPR is, for example, all the cookies that you now see when you enter a website asking you for you agree with this and this and this, and what kind of data transfer do you allow. But when it comes to research, it does have effects, and the effects can be very substantial. It depends a bit on how your country makes a law out of this, because it's regulation in European terms, so it can be has to be transferred into national legislation, and national legislation can differ. So this is something we have to be aware of, and of course I didn't know about Estonia, but for example, I know in Slovenian Italian it's much more stringent than, for example, in the Netherlands. In the Netherlands, when you dialect research and you have recordings and the people have all passed away, then you can do this very easily. But we've noticed in Italy that general regulation then is in Italy, and also in Italy, that you would have to ask permission from the next of kin to publish such recordings. So this is an example. Now, of course, research is a very protected way. You are allowed to do research given certain protections that you do. And data leaks are not very frequent and most of the time not very riskful, don't have much impact. But still, the university would not like to be in kind of wall of shame, for which I have a kind of a link here. You can check it. I will distribute the slides. So we already mentioned a couple of personal features,
And GDPR distinguishes special categories of data for which you can well see that they are indeed very sensitive when it comes to racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union memberships, you see here. And processing of this type of data is prohibited, but there are derogations. Derogations are exceptions in EU terms for research, given that the people concerned have given explicit consent and the data is well protected. So there are more sensitive data. We already mentioned this: location data, financial data. So it means that for our case, if you are processing this type of data at Radboud University, you would have to connect at the local privacy officer. So here, as a consequence of the GDPR, it's not written in the GDPR this exactly, but there are a kind of articles in GDPR that point forward to this privacy by design principle. Our university has developed this kind of research way to go. And there are 8 principles, which you see here, and I will address them subsequently. Maybe I can even play sure if this will work. Maybe I will screw up the whole thing. I will not run the risk of playing the video, because I will explain it in more detail. So the first principle is data minimization. So personal data in research has to be adequate, relevant, and limited, and necessary for the purpose for which they are processed. So the questions that you should ask yourself when it comes to data minimization: are all of your questions really necessary to answer the research question? Or will you be collecting some extra personal data which in fact is not needed to answer your research question, but may become handy in for later or whatever? And this is prohibited. You can only collect the data that is relevant for your research question, and no data harking. Now, you know, perhaps in many countries you do have some national corpora, and for these national corpora, they are for a very broad range of research. They are reference corpora. And in that case, you really must explain in your consent forms for which this data is being collected, and that this is the reason why you also collect this and this and this type of metadata from people, because there's no direct research question, there's not a purpose, it's a reference corpus. But normally, when you collect data, only the personal elements that you need to answer your research question. And a relevant question is also, then, is it possible to anonymize or pseudonymize your data? If you can anonymize your data, then the GDPR does not apply anymore, because it's not possible then to redirect to any living person anymore. So GDPR doesn't count, and you can share the data freely. I will come back to the difference of anonymization and pseudonymization. And that's here already. Sometimes I'm surprised by my own slides, but well done. So anonymization, as I said, means that you cannot go back to the person from whom the data is. And pseudonymization means that this still is possible. So you can think of anonymization, pseudonymization at 2 levels. You can think of the level of metadata, where we have indeed, we have age, and we have name, and we have bank account. And you can have then your observations, for example, the answers to a survey. And you can imagine, for example, in an Excel file, you have 1 row for 1 person, and you would have there the name, the bank account number, the address, and some elements like age and gender. And then the answers to all questions. So that would be 1 nice row. And then for all persons, that would go along the rows downline. So what you then could do is take all these personal elements, which you do not need for your research, and put them in a separate table and give each person a code. And that code is in this one table with all this personal data. and the code is also in the research table with all the answers to the survey. And then it's possible to link back to the personal data through this code. And that's a pseudonymization code. In this way, you have pseudonymized your data, and you can still go back to the original and know who the person was. You can do this at metadata level, but you can also do this in the data itself. For example, when you have transcriptions of interviews, you can say, when a name is in the transcription, you can say this is name, and then somewhere else there's another name, and you say there's again a name, you substitute this by name, and then you've anonymized the data. If you do this for all elements that can point to persons, so perhaps also for locations and gender identifications or professions, then if you do this for everything, say that's a profession and not a profession itself anymore, but just something between brackets or so, you would have anonymized the data. But what you could also do is say it's name 1 and it's name 2. Then you know it's different people, but these you could connect again to the original people. And then you would have pseudonymized the data again, because you can go back to the original. I hope this is clear. When it then comes to audio and video recordings, then you would perhaps use beeps or so to do this. But remember, then you would have made it kind of pseudonymized or anonymized at content level, but still not at the personal level of the voice and the video stream.
But in Google Forms, there is Google Forms. The problem with Google Forms is that it collects IP addresses, but these are not, I can't access IP addresses myself. In this case, is it anonymous data or pseudonym data?
Yeah.
Because it is possible, you know, IP are there, but I can't connect it myself.
Okay, so first it depends on your survey, because there can be lots of personal data as well in there.
Yeah, I
but
mean,
still,
just the other data that there is.
That would be anonymous.
Indirect,
So to
yeah.
speak, right?
Oh, okay.
Then it is anonymous for you, but not for Google.
Yeah.
Well, you can think about what that means. Yeah. So it's still it has a risk for sure. So it's important that when you have pseudonymized data and the links are still there, and you would have a table with the code that would link back, and you would also publish, for example, this code with the data, although the others do not have the other table, under the GDPR, this is still personal data. If you would remove that column with a code, then you could call it anonymous, and the GDPR would say GDPR does not apply anymore. So the other one is data quality, where you can say, okay, the data that you have also always should be correct. And now you have done an experiment and you know where people are living, and then they moved. And then all of a sudden your table is wrong. But it's not relevant for your research that they have moved. But you would like to have the table correct because, in fact, that's your obligation. So how could you solve that? There are two ways. You can follow all these people, ask them where they are now. And with Josh, yes, you take the microphone. I can repeat otherwise.
I was thinking if you just change the name of the data categories to be residents at the time of the research.
Yeah, right. Yeah, and that's a simple solution, and you followed the course before, I think. So you put the date of when the experiment was done, and then it's correct always, right? Yeah. Then we have the goal setting, the purpose, limitation. So you have to describe in detail in your goal setting what kind of personal data you will be processing, what the legal base is, and for how long you will keep this data. So it is relevant to know that for the GDPR, you need a legal basis to collect personal data. And typically this is consent. Because if you do an experiment, you can ask permission from your participants, and consent is one of the legal bases. Now, you can imagine experiments where you cannot ask consent, and I think we come back to this later as well. and then you need something else to do. It is relevant when it comes to purpose setting. That's the other thing. You know, don't just need a legal basis, but also kind of purpose setting. For which purpose are you collecting the data? Where you say, okay, it's for research into this and this and this. The data can not later be used for another purpose. That's also in the GDPR. So you must make clear that for what type of data, for what type of research it is collected. But it's also important to know when it comes to repurposing, there is one article in the GDPR, it's 5, where it says that research is generally always a compatible purpose. So any data set can be used for reused for research without violating the principle. Still, we always advise to make sure that in your consent form set you say it's for research into this and this in these areas, because that makes it much clearer also for your participants. Yeah. It's always a compatible purpose to the original purpose of collection.
You mean research data collected for data collected for research is compatible with reuse in research, not data collected, for instance, as radio interviews.
Well, the idea is indeed that this can be used when it is used for this other purpose. Then you can say research is a kind of compatible in the sense it will not violate the purpose limitation principle. So this is something you can put forward. Yes. It doesn't solve all your problems because of the legal basis, etc., but it is relevant that you can you can connect to this principle when you would like to use this type of data, which was collected for another purpose.
So compatible means compatible with the GDPR.
Yeah.
So research generally is kind of, I mean, that sounds as if research is.
Yes, it gives you
sort of
some
protected.
leverage.
Yeah.
Yeah. That's how it's meant,
Thanks.
in my interpretation. So minimization of use. Well, no, I mean, that's interpretation of also supported by legal persons. So Joshua mentioned the CLARIN community, and one of the communities and committees that we have is the one for legal and ethics matters, and there are lawyers in there, and they say this is the way that you can interpret these regulations. So it's not my personal opinion. Has become my personal opinion due to what others say. Minimization of use. So the fewer people who have access to personal data, the better it is. So really always consider with whom should I share the data, and should they have writing permissions or only reading permissions, viewing permissions. This is another principle to take into account. And it's also relevant to know if you have permission to share the data with others, again, in the consent form, for example. Security measures, so make sure that it's well protected, your data. It means that it has to be stored in very protected places. Encrypted is one way to go. Cloud services that are protected are others. Use data anonymization before it can be shared with anyone else. Pseudonymization, of course, only if possible. Is relevant, of course, when we talk about anonymization, pseudonymization of data. It's always also a kind of data corruption. When you sometimes you enter in a situation where you have anonymized the data such that the GDPR says, wow, great, GDPR does not apply anymore, but it's also cannot be used by any researcher as well because all the relevant information has been removed. So there's a kind of paradox that you face. Transparency, fundamental principle. So you have to be open towards your participants. For what purpose is the data collected and how will it be processed and shared? Also to inform them what their rights are as a data subject. For example, for withdrawing the data, say, I do not want my data to be part of this experiment anymore. And I do not want it to be shared anymore. So relevant things when it comes to the rights of data subjects for research are the right to be informed, and you do this typically by the informed consent document, and the right to be deleted. Now, you can imagine that if you have done your research, you've collected the data, you're perhaps about to share the data, and then two people come and say, sorry, I want to withdraw my data. This has impact on your work as a researcher, because it means that your experiments cannot be replicated anymore if the data is shared. And this is a kind of violation of the basic principle of science and where universities are for. So one of the ways that to prevent this is to say, we collect your data. You can always resign from an experiment, say, I do not want to participate anymore during the experiment. But once the data is collected, we give you 2 weeks, 3 weeks to say, sorry, I do not want the data to be used in this experiment. They don't need to give any reason. They just can say, I want the data to be removed. And this should be in the informed consent form, saying you can do this within 2 or 3 weeks. But after that, it goes into the processing phase, and you cannot withdraw anymore, because this would violate the true principle of us as universities, that we have to do replication of our data. So you can set a date there, and then you can say this is transparent to the participants, and this is the way it works. Of course, if they still would claim, and you can still remove the data because you're not in a situation where it is detrimental or so, then you could do it. But you have to make clear because there is this responsibility that we also have as scientific people. And that's why it's good to think of this in your research design. Now, so is there a standard for this delay period? No, there isn't. You can do something that's reasonable. The important thing is that your participants know. Transparency is the key. And of course, you can imagine that 1 week would be too short in reasonable way. Accountability. So make sure that you know who has ultimate responsibility of the collected data and the various roles. You can imagine that for the RDM policy, it's the researcher and the institute, and the data owner is the university. It depends on where you are and what kind of contract you have with your university, right? Then the basic principle of informed consent. That is the legal basis typically for experiments to collect and process data. And you have to be clear there. So this is an example in these cartoons where things may go wrong. And also this is an example where you could say many things go wrong here. This is someone who does an experiment and then say, come over to me, and we have a discussion about this research, about this topic which is relevant for my research. And then what happens is that there's nothing written down, it's just by telephone, and there's someone else present there as well, a third person, and this person is talking freely about all kinds of personal stuff, and it's all being recorded, and they are drinking a lot, so the lips get loosened a bit better, and they say more than they would say otherwise, etc., etc. And you can imagine that many principles of what was ethically correct, but also in the sense of GDPR of what's correct data collection formed by informed consent are violated here. It is a group discussion here, but I look at the time and I think it's better now to just give this explanation. I share the slides and you can come up with many more examples of what goes wrong here, I suppose. So informed consent, it is an agreement between the researcher and the participant, making sure that the participant is well informed, that the information in the document is understood. And the second thing is there is explicit consent saying, yes, I have understood this and I agree to what is being told about how the experiment will go, how the data will be collected and processed, and with whom the data will be shared. So then indeed, there is this legal perspective and the ethical perspective. And the legal perspective is then what the GDPR says about collecting processing and sharing data. And of course, there are ethical principles in there, but the ethical perspective goes further. It is about what is the good thing to do, the basic principle of treat other human beings like you want to be treated yourself. And that is then reflected in research. So in your informed consent, it typically addresses also these ethical issues. For example, participation is voluntary. The benefits, discomforts, and risks, these are typical ethical things, not related to the GDPR. But then there's a list of what's related to the GDPR, the purposes of the processing of personal data, the categories, the retention period, etc., etc. Right? When we say participation is voluntary, it's an interesting thing that, for example, you would like to give some money to your participants. And now imagine that this would be quite a substantial amount of money. And then the whole principle of whether participation is voluntary or not becomes a question, because people might be looking at their own financial situation, feel themselves forced to participate in this. So it may be the idea is first maybe, oh, that's a good idea, then I will get many participants and it's good for them. But the principle of whether it's still voluntary becomes a bit shaky.
The amounts are rather like gift cards with
Exactly. And then it doesn't change anyone. But then, you know, it's a kind of fair remuneration of the work. And the medical field, yes. Well, we had an experiment where we had people with lower social economic status, and then giving kind of bigger amount is very attractive to them, but it would question again. So also in linguistic research, you can have this question what to do. Yeah. Okay. So this is a screenshot of a consent form template. I don't know if you can read it. Typically, the people on Zoom, I think, but this is a template saying, okay, this is the template. The yellow parts are things you really have to include, but have to make fit to your own research. And the blue parts are only when applicable to your research. Otherwise, you can leave them out. So we do have these kind of templates at our university, at our faculty. I don't know if you have them, but they are very handy for making these informed consent forms. So informed consent can be obtained in various ways. Most common is a written consent form where people can read the stuff and then put their signature, for example, under the consent form. But when you have people who are illiterate, then written consent form is not the best way to go. So you could imagine that you would read out the consent form to these people and then let them sign by making a cross or whatever, or even orally by saying, yes, I agree to this, and record this. And then, of course, also perhaps more common is the online consent form, where you do a survey online. And in this case, you would also need to make sure there's this informed consent, so information, the informed document with everything that we just discussed that should be in there. And then there would be a separate page with the consent, and you would need an explicit consent. So they really would have to tick the box, yes, I agree. It's not that you cannot say if you now click on this screen, we assume that you agree with everything that was said before. A very relevant aspect of the GDPR is that people have to give explicit consent. And that's also the reason why you have the cookies every time. That are very annoying, but it's a consequence of this. Yes. Regulations always brings annoying elements. It's for your own good, but sometimes you wonder if it's necessary. Yeah.
Do not understand actually what you are asking from them.
Yeah.
They understand what they want to. They are very eager to speak, and they are sort of you get to, they are kind of recording and so on, but they just cannot read this important consent letter. They do not understand these concepts. What are
Yeah.
the one?
Yeah.
What would you suggest?
Yeah, so the question is, what do you do if people are older or perhaps lower literate and they would not understand such a form? You can read it out to them, but still they would not understand. And transparency is the cue. We have also done research with people with Down syndrome, where you have the same issue. And what we did in that case is use icons, kind of icons with very short explanations, saying this means this means this. You have to make what they call a plain language statement that's understandable for your target group, and find ways to do this, even if it can't be that fine-grained that it addresses all the legal aspects, but it should be clear to them what is being asked. Yes. We once had the same situation, and the ethical committee said, you have to do this. And we did this. And then at the end, they said, you have to include this paragraph as well, because it's legally obliged. And it was legal talk, which you never could even understand myself, but it was obligatory to add it. So that was a kind of strange conflict. There's a question there.
Yeah. When it's like, when researcher comes or it's participatory research, let's imagine that a researcher is here and maybe there is like a little bit more people here, like 50, and there is like this event and the researcher is observing, taking notes. What about the consent? Should it be taken from all the individuals, or how does it work then?
So the question is, if you have a group of people and
like larger group,
a larger group,
not 10 people, but more
50,
50, let's
if
say.
50 people, and you're taking notes of this meeting relevant for your research, do you have to ask consent of all these people? And in principle, the answer is yes, especially since they are all there. And you can do this after the meeting. Sometimes that's more convenient, but you have a problem if one of them would not give consent. On the other hand, you have your notes. So there are two ways. The explicit contribution of that person is not included because it's notes. So you can see what you can do with this. And by saying you can do it afterwards, you could even do it so much afterwards that you can share your notes and then say, do you consent that I use this? But you would only need to do this if there's something personal about someone, and then you could even look which person that would be. So there are various ways to deal with this. Yeah. But consent remains the key thing here. So the practical tips here is that perhaps you can also digitize when you have forms, and use the digital forms and store them at a safe place, because the paper, if you put them in a drawer somewhere, that may cause a data breach, a data leak. So that's something to take into account. The oral consent procedure, I think we already discussed this, so let's continue. A data breach should be avoided at all times, but typically if it happens, you should inform authorities about this, and also to have them, give them an idea how serious it is. Personal data and social media. I don't know, maybe it's interesting for you because it has, of course, several things that has limits here, because the idea of asking consent is missing here. So it's limited by the GDPR, also by ethics and the terms of service of the platforms from which you are collecting your data. For the GDPR, indeed, there's no way to ask consent. Access to data by contributors, no way, how can you do this? They may withdraw their personal data at any time. So yeah, if you do this, scientific integrity becomes a problem, if they could at all. And sharing then the data with other researchers, yes, you need it for reproducibility, but what are the agreements here? And would you violate the terms of service of the platform if you would just publish the data again? And then with photos and videos that are inside, these are personal data by definition, if you have photos in the posts or so. So the best practice guidelines that we can think of is related to Article 89 in the GDPR. Be transparent in your considerations. Distinguish between public and personal contributions. If it's public contribution that everyone have access to, it's a different situation for specific groups for which there's restricted access and you would have access, but then you see there's a restriction problem there. There are new guidelines now as of October, personal data based on Article 6, which is on legitimate interest as a basis for collecting personal data. So you could take these into account. It allows you to use, or at least with the very transparent documentation, to use broadcast material and social media material on the basis of legitimate interest as a third party. There is this, of course, you have this broadcaster, you have the newspaper, and these are the data owners and the data controllers in the sense of GDPR. And you as a third party, as a university, could use these data based on legitimate interest. But then if you do this, you would pursue this legitimate interest, then make also sure that the data, that if you use this for research, it would not violate any other personal rights of these people. Now, you can imagine if it's recordings, broadcasts of well-known people, they know that this data is outside and being used, et cetera, and it is public data. Then you can well say, there are no, with my research, probably you can make sure that their data rights will not be, but if it's very sensitive data by specific people that you would use, and then it would be harder to claim that their data would not be a violation, depending on the type of research that you do. So there are all kinds of things, but you can go for legitimate interest in this case. When it comes to scraping data, you can use the tools for this. We know, for example, for X, it's becoming far less. It's very difficult now to do this, and also very costly. Do not collect personal data from profiles, but typically these are unreliable. You cannot use these as a reliable source of metadata about people. There's no need to request consent from data subject also because of Article 14, where you could say it's legitimate interest, then you could say it's the purpose that is also clean, and then consent is not at stake because it would be let's say such an effort that is inappropriate for the goal that you have. You cannot approach all these people, so it would be an effort that is too much, and you can refer to this article. Yes, data service cannot withdraw after 2 weeks of giving consent because you cannot approach them in this case. Reuse data by others. Then we have to refer also to the terms of service of many platforms that you might be a kind of, say, competitor of them if you also publish these data as part of your research. So typically we say only use the links to these posts or to these videos, and then say, okay, it's related to this video or this post, and this is my research data connected to this. And then there's a possible problem of replicability, because if the video or post is removed from the platform, yes, there's no access to it to other researchers anymore. But one important thing, document what you do, so that afterwards you can always say, I did it for this and this and this reason, and this is why I thought it was a reasonable and legitimate thing to do. Well, storing data. You have a question?
I have a question about the reuse of this kind of data.
Yeah.
If your analysis includes some kind of like speech recognition and things that for the reuser,
yeah,
in that case, it's quite difficult to do, if not even
Yeah.
it's theoretically possible if I collect the recordings and process them again if I have the links, but actually reusing the data by others would actually mean that it is the posts, the recordings, and the
perhaps, you mean perhaps that some the additional information that you add as a research is so integrated into the data itself that you have to publish it with the data, right?
Yeah, exactly.
So this is a possibility. When it comes to transcriptions of speech, you can publish the transcription and not the raw recording itself, of course, only the link to it. That's still possible. But when you have annotations to, for example, and you would like to publish them, it's hard to do this without. And then you really would have to consider on how to do this. Sometimes when it is a story and your research is in such a way that the order of the sentences is not relevant, then perhaps you can scramble the sentences again and then do it like this. So you look for ways of how not to infringe the competition element with the company. And if that's not possible either, then you have to think of whether can I take the risk of publishing it and say, but I couldn't do it without it, and for research I had to do it, and there's no personal data involved either, for example, because that's also the thing then to consider. Then you could do this, yes. And there have also been sometimes, some years ago, some law pursuits by these big companies on researchers, but these lawsuits were always lost by the company. So there is, of course, legislation and things are changing in these worlds, so we have to be careful now. But you have to make, again, a fair decision for yourself whether or not you can publish it, and before that, what you can do not to violate the terms of the provider of the data. So yes, storing the data, and we all have laptops and we all have perhaps memory keys. I have my presentation on a memory key as well, and that can be lost. And then you are lost in a way as well. Or the building burns where you have your laptop, or you have it in your backpack and the backpack is in the train and the research data is lost. I do hope no one of you recognizes the problem, but only perhaps of someone you know, so to speak. But this happens, right? And it also is true with, say, the more commercial, we mentioned Google or Dropbox, where, of course, the owner is a company, and if they would remove it, I don't know about Google because I never experienced that, but it can happen. Also, your Dropbox account can disappear. So you have to look for ways of fair data sharing. Fair data sharing means FAIR is an acronym of the data is findable for everyone, and it has unique identifiers to point to the data, typically persistent identifiers. It is accessible, so you have a standard protocol to access the data, and it's also clear at what level the data can be accessed. Is it for everyone or only for a limited group? Or do you have to ask permission to use the data for your research? You can restrict these levels, right? And there are also, for example, academic levels. So in CLARIN repositories, you typically see this, that you can say, okay, you have public access, a level more restricted academic access, only for those knowledge institutes that are associated with CLARIN. And then you have restricted, where you have to ask permission from the data right holder to use the data. Interoperable format. So if you share the data, it should be in formats that are common, not a very exclusive formats or obsolete formats, because then you can share the data, but no one still can use them. And reusability. The data should be clearly documented. You can't just publish a table and then say, well, everyone knows how to use it. You need the context. You need how the data is organized. You need the original research question. You need how many people were participating and what kind of metadata there is. So when we talk about open data, it's relevant to know that it is not about that everyone can download the data. Open data means it is as open as possible and as closed as needed. So you can put restrictions on the shareability. You need, when it comes to storing a data, kind of cloud storage, which is considered safe by a university, as a proper backup facility. Proper backup means that there is a backup of the data in another building, because if it's the same building and it burns down, you still have this problem. And also, it would be nice if the backup facility is such that it is incremental, so that you can do time travel and go back to earlier periods. For example, if you would delete data and then think, oh no, I should not have done that, you can go back and take it from an earlier phase of storing. And it has the safety measures to secure data leaks, preventing data leaks. Data documentation is very relevant. I think I explained this. You need the context in which the data was collected and how the data is being structured. That's this. So in that case, when it comes to the structuring of the data, make sure that you use a proper idea of folders and subfolders, the naming conventions of your files. Explain this in your documentation, how this naming convention is. And then it comes to, after your project, when you do the archiving the data or publishing of the data, make sure that you do this in a data archive that is well known and that has good security elements. Can be CLARIN, it can also be Open Science Forum, but also to know that, but make sure that the data access levels are the ones that you need. If you have a repository, data repository that does not have secure levels of restricted data access, then don't use it, right? So the questions or the issues, the topics that you should take into account, are there ethical reasons or legal reasons not to share my data or to share all my data? Where is a safe place to put it? What is the good format? Will my data be accessible in the long term? What are the sustainability conditions of the repository that I use? And do I have sufficient documentation and metadata? So indeed, so there are two perspectives. You need the data for reuse and the shareability, but also the scientific integrity. So reuse is really for you as a researcher, it's part of your networking, it's part of your publication record. It's not only the papers that you publish, but also the data that you publish that establish your position and prestige as a researcher. And for scientific integrity, you need it to make sure that others, or if there would be, say, suspicions of scientific fraud, can go back to the data and see whether all is all right. So when it comes to scientific integrity, that also pertains to data that is not accessible to others, is not shared, but it is stored at a place where, in case where it is needed, authorities can access the data to check whether everything is okay. So for the perspective of reuse, it's the raw and processed data, your scripts and documentation, and the README file where it explicitly says the data is structured like this. Documentation is more about the context of the data collection, and the README is typically about the structure of the database or the data set. And for scientific integrity, additionally, we have these points in italics, the approval of the ethics committee, the informed consent, and the information sheet. That's all there. Not sharing your data, yes. Well, if you cannot anonymize and you do not have permission to share it from informed consent, then you cannot share it. When it's confidential data with the arrangements of a third party, for example, a company for which you do your research, there can also be a block there. And for researchers, sometimes when they do a patent application, you have to withdraw your publication and your data for a time of a couple of months. There's also a possibility to have an embargo on your data, say I cannot publish it now, but perhaps later. And the access levels we already discussed. And when it comes to sharing the data with others, you can use data use agreements. That's when you share personal data in which it is explicitly said under which conditions others can use the data. Right, here are a couple of links which can be relevant for you. And then, well, we are together, just form a group and discuss this. What would your reaction to the ethics committee be for this use case? Take 5 minutes, and people online perhaps can take a breakout room to discuss this. Who of your group would like to tell us what the perspectives were that you considered here?
Well, we had several opinions,
Mhm.
but the most, like the prevalent one maybe was the conflict with informed consent by the participants, right? So we don't have a like solution to this case, but yeah, we had like kind of mixed reactions, I would say.
Yeah,
Like,
yeah,
why?
yeah. Why?
Yeah.
The general why was prevalent. Why, in the sense, why can't this data be shared? Maybe is that the why, or is it why?
I mean, why even it can't be like stored?
Yes.
It's not a case of sharing.
Okay.
Even.
Yeah.
Like stored
Yes.
because I mean, as I understand, there is a consent of
Yeah.
storing it.
And there's one thing that the data should be destroyed, and then it says, but it has to be stored at the National Archive, which feels a bit like a conflict as well. But maybe
Well,
that's for the scientific integrity, maybe.
It says it is possible to archive, not it must be.
Yes, that's
So-
right. But still, it's a conflict, right? With,
Yeah, yeah.
Previous set. Yeah. You would like to say something? Yeah.
It's the paragraph in the guidance states this.
Yeah.
And the
So
whole
what's the
thing about
paragraph in the
national,
GDPR that states this?
yeah, yeah. So why does the informed consent not matter in their opinion? And also the whole thing about the National Archive, it seems
Yeah.
very peculiar. We
Yeah.
just want to know why.
Yeah,
Like, what's their justification for that?
Yeah, yeah, I think that would be a proper reaction. And the thing indeed is what you're addressing is that there's very strange saying GDPR takes precedence over the participants' informed consent. And this is a conflict in itself because consent is one of the bases of sharing data according to the GDPR. So it is, in fact, if you have to put it very sharply, the GDPR takes over of the ethics committee here, you could say. You know, this is not a valid reason because you can't say GDPR takes over of the informed consent, but because informed consent is exactly what was needed for the GDPR to store the data. So it may be that in the informed consent, it was not clear enough that the data could be stored. And then they have a point there because then it's a conflict in the informed consent, but the informed consent form as such cannot be in conflict. GDPR takes precedence over the informed consent is a very strange formulation, I would say. Yes. Okay. Well, I hope you will not get nightmares over this question because I have another one. Perhaps that gives you nightmares, I don't know. So that's this one. For which I think it's relevant to have an idea, also in the same groups, of, Who are the stakeholders in a project? Are you talking about existing data or also about new data that is being generated? What is the personal data? So if there's personal data, it's a GDPR issue. Legal basis for sharing, collecting the data. Do we see special category data here? Is there's a potential? Because that makes it very special indeed, spicy, so to speak. And what is said about the data storage and the data sharing, for how long and by whom. So which aspects in this story I think are relevant? And if you would have to say, oh, it's this one. What would you're giving all these aspects here? Oh, no, I'm going too quick. What would your advice be for this use case? So what legal basis applies, whether there are other necessary considerations, what's here in the last sentence. So what would your considerations be here, and then sharing them with us. But first, talk about this in your groups, say for 10 minutes. If I see that you are too busy still talking, I'd make it a bit longer. Maybe we can go back even on this use case tomorrow. We have some time, but for now, take it for 10 minutes in your group. All right, so let's come back to the general discussion again. Yes, I think you found the solution. It's a difficult one, right? So which one of the groups would like to give their reflections on this use case? I saw some note-taking there at the back, so maybe you would like, if you would, or one of your group. Yeah, yeah. Huge discussions, that's good. Yes, so
the public interests of the Estonian culture being maintained during centuries ahead.
yeah.
You know, so thus we need to use certain materials. But we began by asking whether the autoriõigus just gives the license for scientific work. Autoriõigus means, yeah, the author rights or copyright. So that also like two aspects of the Estonian specific ideas we were discussing. And at this case, that whether using transcripts and just not using voice or video material would kind of help.
Right. So these are three things you mentioned, right? So when it comes to, say, Estonian heritage, I think that was the first thing that should be maintained. Is that the first issue? And then, of course, you say you're not sure if the broadcaster would maintain this. Perhaps that's, I don't know. But then is that research indeed so necessary that for Estonian heritage that this research is necessary and needs the data? That's, of course, then the question. Copyright law, I don't know about Estonian things, but I do know there's, for example, the text data mining rule and the exceptions of it, also for research, which could apply here in a way. The exact copyright law, I don't know. But we also said that perhaps you would not infringe anything if you just refer to the material in the data set that you produce as a result of your research and not copy the data material itself. And then that also points to the third question. If you make transcription of this and only use this, again, with a link to the original material, that could at least solve that part. And the main thing is still if you could use the data and does it contain personal data? That's the first question for the GDPR, of course, and even if it contains special category data. Well, the first question, does it contain personal data? Yes, for sure. It's audio vehicles, people are there, they are recognizable, and maybe they also say very personal and sensitive things that you don't know on this. So that's the first thing, and that would mean that first the thing to do is to find the legal basis to do research with that data. And the other things, of course, are relevant as well, for sure. And it is also sure that you can't ask consent of all these people. So now I'm looking at the other groups, if they had ideas on this.
If it's already published, publicly available, do you need to ask for consent to
the microphone is maybe you're lifting the one. So it's already public data, so do you need consent? I think that's where we were feeling.
Yeah, that's a question that often arises because it is already publicly available. There is nothing that you're republishing, but you're not exposing.
Yeah. So that is the first question, of course, that you have. Then you have GDPR, and it's personal data, so you need a legal basis to collect it, and that's still true. I can't make that difference. So your point of departure is okay, saying it's public, it's already public data. Okay, but what legal basis then would fit if I want to do research with this, and I can't use informed consent?
The best option would be public interest.
Yeah, so public interest is one which is typically for what you call public authorities, and public interest can be raised as a legal ground, for example, the police, tax office, etc., etc. But this is not what we are. But we have the other one, the legitimate interest, and perhaps this is the one that you were referring to.
Yeah, maybe that's the term.
Yeah, okay, but the interesting thing is that there's also public interest. That's why I say. So public authorities can rely on or refer to public interest. Public bodies like universities, so it's not a public authority, can say we would like to invoke legitimate interest. But then again, you have to be very specific about why this is the case, why you can pursue legitimate interest. I think I gave you one hint in my presentation already, indeed, because it's public data. You have a legitimate interest as a third party for the data controller to say, okay, I can use this data for my research, and you have to clearly state this and make this transparent and document this, that was the reason. Then you can indeed start your data collection, I think. And then again, it becomes to the question, okay, will you only publish the transcriptions, but at least when it comes to publishing, only do the links to the original media. You can, when it comes to purpose setting, you can say research as such is already compatible with the original purpose, as we said before, that it would be a path to go. And when it comes to consent, you can say it would be an unreasonable effort to ask all these people for consent. So this would be the line of reasoning to follow if you would like to use this type of data and do research on it. But you would follow this line of research, and then it's not just you as a researcher writing down and go ahead. I think it would be relevant also to talk with the authorities of your university, also perhaps legal people, to say if this would be a valid line to go, because you need the backup of your university for this to go in this way. And I already heard one of you saying, when it comes to legal people, they are the most conservative people in the world. And that's in all universities the case. So if there's any risk for the university, they say, don't do it. And it's always the way of striking the balance. So this is why we have data stewards, because they are in between and they can point towards the relevance of research, but also as a kind of an intermediate between the legal people. And if it's, let's say, we also hope that university attracts legal people that are also on the side of the researchers helping them. And they have to put out, have to think of the risks, etc., but also of ways of how to mitigate these risks in a legal sense. So that would be my 2 cents on this use case. Is there anyone, you have perhaps 1 minute to add something which you thought was relevant here? The other group, maybe.
Maybe just one comment that the risk of only including links is that then you have no control of whether those links are persistent.
Yes.
Which is a problem for
FAIR. Yeah. And this may be, let's say, the sacrifice that you have to do in order not to violate the terms of service of the provider and the data owner. What you could also do is contact this broadcast and say, we are going to do this, and maybe also include the original data in our data set. Yeah. All right. Yes, thank you. We are finishing. I will share these 2 use cases with you today, because it might be that something very clear comes up into your mind, say, oh, that's the solution, or what would be the reasoning on this issue, etc., etc. So we could come back on this tomorrow if you would like. Tomorrow will be dedicated mainly to the DPS, so the Data Protection Impact Assessment role play. I will give an introduction to this, what this is, the Data Protection Impact Assessment, what it contains, and how this role play will go. But I will also come back on today's lecture, whether you have further questions, and I will wrap it up as well. So I look forward to meeting you tomorrow again. Part, I should say, the 3rd part of this course. What we will do, well, first, let's see again what the learning objectives are of this course. So the idea is that at the end of this course, at the end of today, then you will know what personal data and research is. We discussed lots of this yesterday already. You know the basic principles of the GDPR, 8 elements of privacy by design, relevant aspects of safe storage, sensitive data, the basic principles of a data protection impact assessment, which is on the menu for today. Yesterday, you had some practical experience in assessing a use case too, actually, and some practical experiences in conducting a data protection impact assessment will be done today. All right. So wrapping up, what we learned yesterday is privacy by design in research and the group discussions that we had. So we distinguished between 2 types of identifiers. So the direct identifiers, which are typically needed for the administration of your project. We also said that personal data is data that allows you to identify a person. So some combinations of personal elements like age and gender do not identify people, so they are not personal data in that sense. GDPR has special categories of personal data, which we mentioned, and they need special care in terms of informed consent and data protection. We consider the 8 principles of privacy by design: data minimization, data quality, goal setting, minimization of use, security measures, transparency, rights of data subjects, and liability. Welcome. And these will also come back in perhaps a bit different form in the role play that we are going to do. I would like to come back to one thing about data minimization, where it comes to the age of the participants. So there are 2 ways to know the age of the participants. The one is to ask for the age, and the other one is to ask for the date of birth. If you would have to choose, which of the 2 would have your preference? Day of birth? Yeah, day of birth. And when you look at it from the minimization principle, is that still the case? Because in that case, it's better to just have the age of someone, or even an interval in which the age is. This is relevant for your research to only know the age interval. Then this is much less identifying in combination with other things that you know about a person than the day of birth, because that can be found everywhere. Or everywhere, but in many places. So day of birth, we consider more specific as a personal identifier than age, in fact. So I forgot to tell this yesterday, and I hope this is clear.
Interval,
yeah, age interval.
Age is not ideal for data analysis. It's often it's preferable to have that, or at least an option to first test the age variable as a numeric factor instead of categorical, because numeric factors.
But if you say, if you say have an age interval and it's sufficient for the analysis just to take the average point in between, then that could help. Yeah. It depends on what your research question is, right? Yeah. So we talked about informed consent procedures as, say, the main legal basis for collecting, processing, and sharing personal data, where this consists of 2 parts: the information to the participant, and then the explicit consent. Sharing and storing data during your project. So we talked about the dangers of using memory keys or your own laptop for collecting data and working on this and have at it no other place. The risks are first that you may encounter a data leak with your material. And the other thing is that it is you can lose the data yourself when something happens. So this is why we always recommend to use university storage, cloud storage, where you have safe access and protection measures for the research data that you have. So after research, it's a matter of archiving and publishing data. And there we gave several options, like, for example, we have the CLARIN B centers, which are data centers. Most universities also have a repository that you can use for sharing data. And it depends also on the work and the project that you're working on. If you're working on a European project, for example, with many partners from many countries, then perhaps you, as a project, choose one of the repositories in which you publish your results and data sets rather than specific university repositories for each partner. So then here we have the questions, also the questions that that remained after yesterday. Yes? I get a microphone.
Thank you. Because I work with children, so I gather child language data, so I
Yes.
get informed consent from the parents. And of course, I have all these elaborate informed consent forms where I have listed all the things that the ethics committee wants me to list there, and it's like quite thorough. And some parents are very interested in it and they read it through and they want to keep a copy and they're like very aware of their rights, whereas others just kind of glance at it and kind of just ask, oh, where do I sign?
Yeah.
And they don't really read the whole thing. Which, you know, I'm not gathering any like specifically sensitive data. It's sensitive just by virtue of being from children and being, you know, their voices and so on. But still, it's not anything that could like actually, you know, threaten the children if it leaks. But still, you know, it's their personal data. So I'm like, when I see that people aren't taking the informed consent very seriously, like, should I, as a researcher, is it my role to kind of make them aware that they should read it properly, or is it their choice?
The problem that you mention is not only for parents and children, it's for all kinds of participants, all kinds of experiments. I trust you.
Yeah,
and then
exactly.
they put the sign there. And then there are two ways. Of course, you can ask them to just to read it thoroughly, that they really know what is in there. Not that there's something dangerous, but you would like them to do this. But on the other hand, also, in the end, the responsibility is theirs, that they put the signature there. So it depends a bit on the relationship that you see. If you can ask them again, well, have a look at it. Or otherwise, okay, they say, I trust you, I thank you, but perhaps it is anyway good to read what we do with the data. But in the end, it's their responsibility to sign. Yeah. Okay, so now we come to something else. It even might be that they say, I trust you, because they can't read it themselves. That's illiteracy. And then I think Patel,
yes,
yeah, gave a good idea that you can summarize orally to them what's in there. So let me rephrase and then, yeah. Good. A question in chat. And that is, because I can't see that.
I could, here, it's okay. Henk, I can read it. It's okay.
Okay.
Are there any challenges specific for the field of linguistics? For example, when it comes to anonymization, pseudonymization, many data protection issues are general for the humanities or social sciences, but are there any certain issues affecting linguistics research?
Yeah, it depends really on the type of linguistic research. So if you're interested in how sentences or the syntax of sentences are, and you do pseudonymization or even anonymization, then from the labels that you get, it's still clear what the part of speech tag is, so that you can still do linguistic analyses. But it really you really look into the semantics of things, then it depends really on what is blurred by the pseudonymization and anonymization process that can even render the data unusable. Yeah, it's a kind of general answer, but I think it really depends on the research question that you have and the type of linguistic research that you do.
Means that we can't study names, for example, if you have to anonymize.
Yes.
So
Yes.
into names.
Yes, it's not interesting to see, we have 80 occurrences of the label name. So, indeed. Yeah.
I have a question. If you just mentioned OSF as a repository.
Yes.
It's been a while, but a few years ago I had looked into this, trying to understand what or who is behind OSF.
Yeah.
And I was very confused.
Okay.
It led me to something in Virginia in the US, but I didn't really figure out based on what I could find. I was wondering if you know anything.
Yeah, so I know that there are
GDPR.
projects that use Open Science Forum, OSF, for this. And our recommendation is always to look at the sustainability of such a forum and if it's and what the protection measures are for a specific type of data. Now, if it's all open data, it's a different thing than for very, very sensitive data where you need restricted access. Does this repository allow these layers of access, yes or no? And that's all decisive for whether or not a project should choose this. And if you have, say, well-educated doubts about this, then would choose another one for sure. Yeah.
Well, because I know it's quite common.
Yeah,
but I don't know if I couldn't figure out where their servers are actually located. And this idea of having the data on servers in the EU seems relevant in GDPR.
Yes.
But I couldn't. I mean, maybe this has changed. I haven't checked for a while.
You can even choose the server within OSF.
Okay. Yeah. So maybe that's changed.
Yes. So that's one thing. You would like to have the data on European soil, so to speak. But still, if it's say an American company, for example, they still can claim access in any way to the data. Times are changing, so I wouldn't have said this, I think, a year ago. But, yeah. Any questions, perhaps also? Oh, there's a voice in the air.
It's probably, I don't know, construction.
Oh, it's construction work. So
there's a possibility that there's drilling today.
Okay, okay. Maybe it was some drilling. Yes, an extra participant. Any other questions, or otherwise, perhaps, how the use cases that we discussed yesterday? No. Then let's continue. So the role play use case. Some people do not like to have role plays because they think they have to impersonate some person, but this is not what we are aiming at. We're looking at a relaxed way of discussing how you can deal with data, and then you take a role of, say, a stakeholder. But please remain yourself. So what's such a data protection impact assessment? Well, it is not always required. It's only required under the GDPR when processing or the use of new technology is likely to cause a high risk to the rights and freedoms of data subjects. So this is something special. It has to be examined whether data protection impact is necessary. So this DPA is designed to describe the processing, assess necessity and proportionality, and help manage the risks to the rights and freedoms of natural persons resulting from the processing of personal data by assessing them and determining the measures to address them. DPAs are important tools for accountability as they help controllers not only to comply with requirements, but also to demonstrate that appropriate measures have been taken to ensure compliance. In other words, a DPA is a process for building and demonstrating compliance. And this is why transparency and documentation of your considerations and assessment and decisions is very important here. There are seldom very straightforward things when it comes to a data protection impact assessment. Well, the decision whether or not such an assessment is necessary is sometimes quite obvious, but then how to proceed and to make a decision, that involves all these stakeholders, in fact, and everything that is relevant there. And that should be clearly documented when a decision is being made. Again, with a view on the compliance on the GDPR. So, as I said, sometimes it's very easy to know when you need a DPA. So it's always needed in case of the following conditions. Covered investigation, you see the whole list there. And I think relevant for for linguistics, typically maybe are the two ones that I highlighted in red. So when you're dealing with health data or with biometric data, but sometimes when you do research into a very specific or what we call special category data of the GDPR, like genetic personal data here, then such a DPA may be relevant as well. Okay, so in order to assess this, yes, the
Can you just
question.
say something real quick about biometric data, or maybe you'll come back to that. What exactly does that mean? I mean, I know it from my passport.
Yes,
That's
yes. And sometimes, welcome, sometimes biometric data, voice or faces are considered biometric data. I remember we did a research project on sign language at some point, and we would like to collect some data of participants doing some sign language. And the ethics committee said, oh, this is biometric data because faces can be used, and also we also collected voices. Voices can be used for biometric purposes. And there, I think it's good to make the case that you're doing linguistic research and that the data is not intended and doesn't collect any other material that is indeed meant for biometric identification. It's a linguistic research. You're looking for language behavior, not for biometric stuff, because these databases are different in a way, and they are set up in a different way in order to make biometric identification possible. But still, as you see in these days, so many data can be combined that even if you do this, it can be used perhaps in another way. And that's why ethics committees are sometimes very reluctant to do this. But our stance has always been what we are collecting is for language behavior research. And it doesn't have the qualities that are required for a biometric database collection.
So biometric data is a person's image?
Yes, but really intended to train and test systems for biometric identification.
Can it be something other than just an image?
Yes, also voices can be used for this, and fingerprints, and yeah.
Right. I guess I always think about my passport and I wonder, it's like new passports have to be biometric, but
yeah,
I don't actually know what that means because my passport doesn't really look that much different than my old passport.
Oh.
But it has data like that stored in it somehow. I don't.
Your fingerprints
Are
they
somehow in the chip.
Are they in the chip, the fingerprints?
Right.
Okay. So there's a question here about passports, and I've no answer to this.
Because that's what I think of when I hear biometric, and I don't think about linguistics.
Yeah. No, exactly. But that is the stance we also take. We are doing linguistics and not
Would you
biometric.
consider EEG data biometric?
I don't think so. Can you, when you have the EEG signal, can you say which individual it is? I don't.
Well, probably, probably not. But I think there are different views on that in different countries.
Okay.
From different ethics committees.
Okay, ethics committees. Yes, okay, that can be different because they think it's the brain and therefore it's very personal. But still, so if you do, for example, eye tracking experiments, we wouldn't say this is personal data, but it's very personal eye movements. And so you have also brain signals which are of your personal brain, but can you direct re-identify a person on the basis of EEG? I don't think so. But, perhaps when there is, for example, a very specific brain disease or which is visible and then is so unique or very, very unique that with some very small extra thing, protection impact assessment, in order to find out whether you should go into the whole process. And then there's a couple of questions which are mentioned here. Are they assessed on the basis of personal characteristics? Is there a question of automated decision taken that have legal consequences or similar substantial consequences for the data subject? Is it systematic or large-scale monitoring? Sensitive personal data processed? Is it large-scale processing? Personal data from multiple sources linked to each other, compared to each other, set of personal data enriched with an additional data of vulnerable groups, new technologies used in the processing. Is it more difficult or impossible for people to exercise one or more of their rights, or as a result of the processing, not to rely on a service or agreement? Are personal data transferred to countries or organizations outside the European Economic Area, or to a country for which no adequacy decision has been taken? So, and the idea is if the answer is, to one of these questions is yes, then data protection impact assessment is a wise thing as a follow-up. And of course, it depends a bit on which of the questions is answered positively, on how deep that should go. So, coming to the practice of the role-play material, so I should give credit to my colleague Esther Horn, who developed this role-play. And she also adapted it for several communities, one of them being DELAT, which is a community and an initiative to share data of people with language and speech impairments. Esther is a member of CLARIN's Legal and Ethics Committee, but she is retired now. And she's very happy that her work in the sense of this role play still continues to be relevant and used. Okay, so the method is a multi-stakeholders role play. It provides a structured way of thinking about risks and protection measures, and they are based on protection goals. And these protection goals have 6 dimensions. So it's confidentiality, integrity, transparency, intervenability, unlinkability, and availability. And well, you can see this is closely linked to the 8 principles that we also discussed for privacy by design. So when it comes to confidentiality, it's about to protect the data from an unauthorized person. When it comes to integrity, it's about data are intact, complete, and up to date. When it comes to availability, it is data must be available during the project and to authorized parties. When you talk about unlinkability, data shall be processed only for the purpose for which they were collected. Transparency of the entire data processing operation with the participants and with the authorities. And intervenability, guarantee the rights of the participants at any time. So these are the aspects that are related to these cells. So, and what are the safety measures that are associated to this? When it comes to confidentiality, we need a secure authentication system. When it comes to integrity, we need restriction of writing and modification permissions. When it comes to availability, it's also about data backups. When we talk about unlinkability, it's about pseudonymization, anonymization. Transparency, we need informed consent for the participants, documented discipline-specific good practices, information about the right of the data subjects, the participants. And for intervenability, a single point of contact for the rights of the data subjects where they can turn to in case they have questions. So the material was presented at the CLARIN annual conference. There are several links that you can use here. And for the role play, what we would need, well, is a use case. We need role cards, and we do have them. They are here, kindly provided by Tavi. And the roles that we will distinguish are a researcher, a member from the ethics committee, a security IT expert, legal know-how. Of course, these are the people that are most hard to get mostly in a role play, but we'll see. You can take the role and see what will happen. The data subject, or a representative of them, and the data manager of the archive. So these are the 6 roles that we will distinguish. So for what we have here is this use case. I will just read it out, and later I will keep it on the screen. So we have Valeria and Alexei. They collaborate with a research group working on language acquisition and language attitudes. This group comprises several partners, including a number of EU universities, as well as primary and secondary schools. So that's interesting for one of us. I remember your question. Valeria and Alexei are looking to collect school students' linguistic autobiographies, which is a non-fictional genre where each student explicitly reflects on the relationship between themselves and their languages. Their aim is, 1, upload these autobiographies on a web platform in order to raise awareness of personal trajectories and experiences of language acquisition, and 2, make them accessible to other researchers who are collecting comparable data in other EU and non-EU countries. These autobiographies will be collected directly by teachers as part of their teaching activities, both in primary and secondary schools, with students aged between 6 and 18 years. However, some of the teachers have already informed the researchers that they have already students' linguistic autobiographies and are happy to share them, whereas other teachers are skeptical about requiring consent forms for underage students. Even if the autobiographies are collected anonymously, they may contain personal information such as migration background, birthplace, etc. Due to this, Valeria and Alexei are concerned with the potential implications of data sharing and verification as part of their work. And so this is the use case. What are the risks in collecting this material and sharing it? What are the measures that can be taken to make the risk minimal? And what is your assessment in the end? So if we go to look closer to the game, who are the stakeholders in sharing the data? Which personal data is involved? What is the legal basis for collecting and sharing the data? Is there special category data involved? Where is the data stored after the project, and for how long, and with whom will it be shared? And do we need access levels and licenses? So preparation of your role, what's the goal of your character at a session today? What does your character want to have achieved when the session is over? So, and the report outline is like this. I already introduced it a bit. So what are the risks? Does the currently envisaged design of data collection and processing ensure compliance with the respective data protection goals and the key concept of the GDPR? If not, document under what circumstances a risk to the data protection goal is possible, and document points of discussion. Which risks are data subjects likely to face as a result of an infringement of their rights and the goals of the GDPR? Then second part is the measures. Which measures were discussed to address risks, high risks, to the data subjects? Indicate which stakeholders should be involved to implement the measure. And then a final assessment. What is the conclusion of your group regarding necessity and proportionality of the collection and processing sharing of the personal data? Did your group conclude that the collection and sharing of the data is feasible when taking identified risks and mitigation measures into account? And the results can also be that there are no sufficient mitigation measures to solve the risks, and that you would recommend not to go into that direction and not collect the data or not share them or, well, whatever. So that is the goal for today. So and sorry. Okay. Yeah. Yeah, back in the main room. So all of you hear me again, I hope. So it was a bit later than I initially thought, but that's only good. We had a fruitful discussion, I think, in our group, addressing all kinds of aspects related to it. Not addressing all issues. You would need more time for this. Since I was the reporter myself for this one, I will. So what we did, we inventorized a couple of risks that were put forward by the individual stakeholders, and then thought of some mitigation measures that could counter these risks, and then at the end say whether or not we could agree with the project to go on, provided that the mitigation measures were taken into account. And so with what we could already identify, the project could go on with a couple of mitigation measures. I just mentioned a few which we found. So for the data, we think pseudonymization, anonymization would need manual supervision, and note in the consent form that part of personal information may still remain after the anonymization process, and thus be used during the research, but also for sharing and publishing the data. There will be paper versions of these autobiographies. They should be minimized as much as possible, should be collected in a digital typed form, but probably it's inevitable that there will be handwritten texts. So for that, we can provide a safe tool that is already there. And also here some hand correction will be needed. Participants would like perhaps to retract their data. That's their right. So we would put in the consent form that this is possible after 2 months after the collection. We will ask the teachers that already have collected data to make sure that there will be consent forms for these, so that will be a post hoc consent form. And it also allows us to, I think, to alineate these consent forms with the consent forms that we will have for the new data. University servers will be used to store the data during the project because they are considered safe. Data publishing and sharing after the project should be done in a safe repository, perhaps a CLARIN B center. And the other data that's not published should be kept on the university server for scientific integrity or deleted if allowed. The pseudonymization key should be deleted at the end of the project. We do not see that it is needed for scientific integrity as long as the other data is there. And different consent forms will be provided for children, parents, and teachers. And teachers should be instructed about what they can do with the data when it comes to showing or publishing, for example, to avoid that they will expose writing errors of specific individuals. And we would require GDPR compliance for sharing data with non-EU countries. So these countries should then make a statement that they will comply with GDPR regulations and the data use agreement that is provided to them. Okay, that was it for us. I enjoyed it very much. I hope you did it as well, to see it from different perspectives and to see what is in it, and that it's really a discussion which has to be documented. It's not a straightforward thing. So maybe there's also some comments from or ideas from the other group, the breakout room that we had. Perhaps we can even hear them here if there's, I don't know.
We can turn on the audio if someone wants to say anything. But first, yeah.
Yeah. If not, it's okay. We do have your report form, and we can have a look at it. Oh, maybe I can, if I go down. Is it here in group 2 online? Yes. Oh no, this is not there. Oh yes, it's also about anonymization and a sensitive background for the migration background, location, but yeah, we also discussed these metadata stuff. Yes. So the metadata then indeed it should be made sure that this is not identifying persons. So I see your conclusions, I think, is also here. The research project is feasible as long as some corrections are made. I see here. Researchers provide consent forms to children older than 18 or their parents for younger children. Researchers provide a straightforward way for removing data when the data subject wishes to do so. And perhaps that's in line with what we said, if there's some term, a time limit put to this. Guidelines for teachers to pseudonymize the autobiographies. Oh, that's interesting. So you propose to do this already at the teacher level. That's at least one way to avoid perhaps that not necessary personal information is already shared with the researcher, but it also runs the risk that there are different pseudonymization protocols than in line 1 for the teachers who use what they think is right, or then you should perhaps make sure that they use the same pseudonymization tools, etc. If you use tools, it may become complicated and you may end up in a situation where you think, okay, it's better if we do the pseudonymization, because it would also mean that the teachers should spend much time on this. Perhaps it's not for the metadata, that perhaps is easy, but for the full text that are provided, it can be much more laborious, and you could not require them to do this. And the other thing you propose is guiding questions for students to add relevant and comparable data points to their autobiographies. Yes, so to guide this autobiography data collection. It's a very interesting thing. Yes. All right. So I hope you enjoyed it. Perhaps some evaluation remarks from your side. Anyone? On the role play? On the course, maybe?
I think I just want to say that it would be great to have the slides.
Yeah, yes,
Because there's a lot of
sure.
information there, and we went through
Yes,
it
I
fast,
know.
and I could consume it and make notes.
Yeah,
So
you will get them,
yeah,
for sure. And how was it doing the role play? Was it helpful? Does it help you to process the information and make it kind of your own, so to speak?
Yeah. I think like this use case, it's really complex.
Yes.
And it's hard to
Yeah.
think about all that and think about the role.
Yeah.
But it's probably quite realistic that these things are complex.
Yes, that's true. It is complex because it contains so many aspects that need consideration. And then for a role play, it's nice if at least a few of them are addressed, and so it can't be complete. And most of the time they are complex, but not that complex, I think. Yeah. All right, then.
It would be useful to have the role play with also participants who actually come with the background described here, because like giving legal advice, taking the role of legal advisor is not very comfortable if you don't have the legal background.
Yes, but still, I think it's true. But with the role card, you get an idea of the questions that you could ask and are relevant here, and that could be discussed. But it's evident that you cannot get to say a highest level for an assessment that would be required in real life. But I think for a role play, it's relevant to know what kind of aspects can be expected as input from different observers and stakeholders. But of course, yes, it's a role play. That's right. No? Okay. Then I thank you for your attention and participation. For me, it was a pleasure. Thank you.
Thanks.
Again.